Welcome to the July edition of Lunch and Law. Terrific to be with all of you again, both here in our live audience and those of you who are tuning in remotely. For today's topic, the U.S. Supreme Court saving civil liberties or barely bothering. Before we're jumping into the three cases on which we're going to focus today, I'd like to take a moment to do two things. First, as our summer clerks are leaving, or at least most of them are leaving at the end of this week, I just wanted to take a moment publicly to thank them for all the terrific work that they have done for us here at the New Civil Liberties Alliance this summer. I know I speak for all of my litigation colleagues when I say that we couldn't have done what we did without you. The force multiplier effect of having the clerks here every year is something that we really feel and know and super appreciate all of the valuable work that you guys do. The second thing that I wanted to take a moment out to do is to toot NCLA's horn for a little bit. I'm holding the 6 amicus briefs in my hand that NCLA filed on the merits at the U.S. Supreme Court this year, which led to a perfect 6-0 record at the Supreme Court. And so I just wanted to take a moment to congratulate my litigation colleagues for that achievement, and not just the litigation colleagues, but everybody from Philip, who, as always, is involved in what we do in these cases, to our comms team, paralegal efforts, everything that went into the successful record at the Supreme Court this year. So I just wanted to congratulate the team for that. Having done that, let's jump in terms of the three cases that we're going to be focusing our discussion on today. As the somewhat ambivalent title portends, the victories we'll be discussing today may not have delivered everything that they could have, or did they? We'll be asking our three panelists. On my far right, Richard Samp. I can't always say that. On my far right, Richard Samp, Senior Litigation Counsel for NCLA. Rich has been in private law practice for 40+ years in Washington, D.C., specializing in appellate litigation and constitutional law. Most of those years were spent at the Washington Legal Foundation, where I had the privilege to work with him for over 4 years. And he has directly participated in more than 200 cases before the U.S. Supreme Court. Rich is a graduate of Harvard College and the University of Michigan Law School, and he clerked for a federal district judge in Detroit. And Rich was the author of NCLA's amicus brief, or co-author of NCLA's amicus brief in AMG Capital Management v. Federal Trade Commission. Nick Reaves, we're pleased to have with us today. Nick is a counsel at Becket, and where he practices First Amendment and appellate litigation for them. While at Becket, Nick has worked on precedent-setting religious liberty cases nationwide and was part of the team that secured the unanimous victory in Fulton v. City of Philadelphia. So we're pleased to have him here to talk about that today. Nick's writings have been published by the Yale Law Journal Forum, the Notre Dame Law Review, Law and Liberty, and the Virginia Journal of Social Policy and the Law. He was a litigation associate at Jones Day before joining Becket, where he also focused on appellate and trial court litigation, and has argued in federal appellate and district courts, helping clients with numerous bet the company matters. Nick clerked on the U.S. Court of Appeals for the Third Circuit, graduated from the University of Virginia Law School, where he served on the Virginia Law Review and was elected to the Order of the Coif. He graduated magna cum laude with a double major in economics and political science from the University of Notre Dame. Last but not least, our brand new colleague here at the New Civil Liberties Alliance, our Chief of Litigation and Director of Strategy, Jeffrey Bosser-Clark. Jeff brings decades of government and private sector experience at the highest levels of complexity to his role as NCLA's Chief of Litigation. He was Senate confirmed with bipartisan support as the 35th Assistant Attorney General of the Environment and Natural Resources Division at the U.S. Department of Justice, followed by dual hat service as the Acting Assistant Attorney General of DOJ's Civil Division in 2020. Previously, he was a partner at Kirkland & Ellis, where he focused on appellate litigation, administrative law, and environmental law. He's a former member of the Governing Council of the ABA's Administrative Law Section, and a former adjunct law professor at what is now called the Antonin Scalia School of Law at George Mason University. He has argued in all of the U.S. Circuit Courts of Appeals and clerked, as I did, but not at the same time, for the Honorable Danny J. Boggs on the U.S. Court of Appeals for the Sixth Circuit. Jeff earned his A.B. from Harvard University, a master's degree from the now Joseph R. Biden Jr. School of Public Policy at the University of Delaware. Of course, it would be at the University of Delaware. And a JD from the Georgetown University Law Center. So with those brief introductions, let me jump in first on the AMG Capital v. FTC case, Rich. This was a unanimous decision from Justice Breyer, holding that the FTC Act does not authorize FTC to seek or a court to award equitable monetary relief, such as restitution or disgorgement. Now, the FTC has been using this power under Section 13B, and maybe you can tell us more about that, for 30 years. So what changed? Why crack down now?
Well, unfortunately, it did take 30 years. I think that this is much more a cautionary tale about administrative agencies running amok than it is any major shift in administrative law. I think it's pretty clear if you read the statute that the FTC never had the statutory authority that it was using, but it took this long for the Supreme Court to finally agree to hear the issue, because unfortunately the courts of appeals had unanimously for a very long time gone along with the FTC's overly aggressive interpretation of its powers. And it was only when 2 years ago, when the Seventh Circuit stepped in and said, wait a second, we want to rethink what we said earlier. We don't really think the FTC has this power. That created a circuit split and caused the Supreme Court to step forward.
So are they the heroes in the tale, the Seventh Circuit, for finally sort of waking up here?
I think so, yes. And there were also some judges on the Ninth Circuit who said in this very case, well, we think that we're bound by circuit precedent to uphold what the FTC has done. But nonetheless, we want to speak up and say maybe the Supreme Court ought to take a look at this. Basically, what happened was that the FTC, which was created almost a century ago, their power originally was to take a look at business practices, and they could declare that the business practices were unfair and could issue cease and desist orders. And then if the company didn't agree and didn't go along, at that point, the FTC had the authority to go into court and get an injunction to enforce its cease and desist order. But as time went on,
so this was prospective kind of relief,
nothing to do with damages. But as time went on, the FTC said, well, you know, sometimes there are some pretty bad actors who are engaged in fraudulent practices, and it can take us a couple of years to complete these administrative proceedings. And in the meantime, the company continues to defraud consumers, and we don't think that's a good idea. So please, Congress, give us the authority to go in and stop the misconduct while our administrative proceedings are going on. And so that's what Congress did in 1973. It adopted Section 13B that allowed the FTC to go into court and get injunctions as a stopgap measure until the cease and desist proceeding could be completed. And then at the same time, they gave the FTC authority under Section 5L to go ahead and get damages in the event that there was a violation of a cease and desist order. And then 2 years later, Congress even went a little bit further, and under Section 19, it gave the FTC the authority to actually get monetary awards in cases in which there was a cease and desist order that had been where there was an established violation of the FTC Act, and you could go in and get a limited amount of damages, not unlimited amounts. But Some people at the FTC thought that was not enough. They thought it took too long for them to go through these administrative proceedings. They wanted to jump right into court and sue for damages, in particular to get restitution and on behalf of consumers, even if they really hadn't identified particular consumers that had been damaged. And so there's a lot of internal FTC memos that demonstrate that people at the FTC say, well, probably we don't really have this authority, but why don't we ask for it from the courts, and maybe they will allow us under Section 13B to go forward. And so that's what started happening in the 1980s.
And did they assert this authority against Fortune 500 companies and really like well litigated cases with strong opposition?
No, they began with figuring, well, if we get people who are obvious fraudsters who really don't have the resources to fight against us, that's the way to establish this precedent. And that's what they did. And lo and behold, courts started going along with them. I first got involved in this issue about 10 years ago in a case in the Fourth Circuit, which was one of the few circuits that had not yet ruled on the issue. And the Fourth Circuit's attitude was, well, maybe Mr. Samp is correct and FTC doesn't have this authority, but who are we to go against what all the other circuits have said? So we're going to go along. And so, as I said, it was a unanimous.
Behold the independent judiciary.
Right. And once the case got to the Supreme Court unanimously said, of course they don't have this authority. Section 13B says that the FTC has the authority to go into court to get an injunction, and in a proper case, they can get a permanent injunction. But an injunction doesn't mean all sorts of equitable relief, such as restitution. Rather, an injunction is a specific sort of remedy that doesn't encompass getting equitable monetary relief. And so the FTC lost. Now, at this point, I've talked to a lot of companies that are reputable companies, and their general feeling is, we never really fought very hard against this rule because we kind of prefer to have our day in court rather than to have to be in front of an ALJ at the Federal Trade Commission, because we kind of look upon those proceedings as a little bit biased.
Yeah, I was going to ask you that. So why complain that the FTC bypassed the administrative process and went straight to district court? Isn't that what NCLA wants in other contexts at the SEC and so forth?
Yeah, I think that what the NCLA really wants is for administrative agencies to follow the law and not make it up as they go along. Now, I suspect that the FTC isn't really happy with having to go in front of their own ALJs, because they realize that can take years, and they liked being able to hold a hammer over the head of companies and saying, look, here's this lawsuit, and you better give in right now, or else we're going to collect billions of dollars in damages, which they did in other cases.
Well, in this case, 1.27 billion in restitution and disgorgement was at stake, so not peanuts.
Right, and so I suspect that the FTC is very unhappy with this decision, and they will go back now to Congress, which is the appropriate thing for them to do. And I'm hoping that Congress comes up with a reasonable new law that does allow the FTC to go into court to collect damages from companies that are fraudsters, and that they can get restitution on behalf of consumers, but that there will be, just as there currently is under Section 19, there will be real limits on what they can do, so that, for example, any damages will be limited to, or any effort at restitution will have to be limited to actual identified victims, and to the extent that they want to get disgorgement of unjust profits, that those be limited to real net profits, and not the way the FTC has been doing it, and seeking to get gross income. And also, the FTC has been trying to go in to use their Section 13 authority based on conduct that took place in the past, where they say, oh, well, you did it once before, so we think you'll continue to do this, and so we can sue you. Rather, there ought to be a reasonable statute of limitations, which they have not had up to this point.
And that's, well, first of all, congratulations on getting your opinion in front of the Fourth Circuit from 10 years ago, finally vindicated by the Supreme Court. So that's good. But that's part of the problem here is that the FTC, by proceeding under Section 13B and not under Section 19, they were ignoring all of the limits that Congress put in on seeking monetary relief, as I understand it.
Yes, but Section 19 does require an initial administrative proceeding, and I think it might be appropriate for Congress to say, no, you don't need to go through that, but if you are going to go directly to federal court, there ought to be limitations on the remedies that you can get.
Terrific. I have one more question, and I'm going to jump to Nick on Fulton, but was the FTC actually sharing the money that it gained in these proceedings with victims of, of the fraudsters, or was it keeping the money for itself?
It was generally keeping it for themselves because they rarely were able to identify actual victims. On the other hand, of course, when they're dealing with real fraudsters, very often they would issue these press releases about how they recovered $1.7 billion, but maybe they would see a couple $100 in that. I mean, they never really collected the vast
money was
amount.
gone, right? As fraudster money often is. Well, I'd like to have a great segue to Fulton, but I'm not sure that there's a whole lot in common between AMG and Fulton, other than they are both unanimous decisions. Fulton Sharonell, this is your client. Am I pronouncing it correctly?
Yeah,
Sharonell Fulton, the city of Philadelphia, and a unanimous decision by Chief Justice Roberts, although Alito, Thomas, and Gorsuch did concur in the judgment. As I understand this case, Nick, the holding is that the refusal of the city of Philadelphia to contract with the Catholic Social Services over providing sort of placement for foster children is a violation of the First Amendment. Is that right, or how would you encapsulate the holding of the case?
Yeah, I think that's right. I mean, it kind of depends on the level of generality, but there's a specific line from the Supreme Court that says the city of Philadelphia can't refuse to contract with Catholic Social Services on the basis of its religious beliefs and its inability to endorse and certify same-sex relationships. I think there are a few things. I was looking at the opinion again this morning before we chatted, and there are a few things that jump out to me, specifically in the context of kind of government authority and kind of limiting the role of government too. One is the court pretty clearly rejected the city's argument that when the government is acting as a regulator or acting as a manager, it has additional discretion and is not subject to constitutional standards. On the facts of this case, the city argued that because Catholic Social Services is a foster care agency in the city's foster care program, the government doesn't have to respect their constitutional rights. They can just impose whatever requirements they want through the contract. And that was a kind of the main focus of the city of Philadelphia's Supreme Court brief, kind of a pivot from what they had argued before.
And is the theory there that because you've signed a contract, you've agreed to let me violate your constitutional rights?
Yeah, I mean, that's what the city was arguing. They were saying, we're managing a foster care system. CSS is a contracted entity. Therefore, we have this discretion. We're not subject to heightened constitutional review. And the Supreme Court, out of hand, all 9 justices rejected that argument. And to go back to your first point about this being a unanimous opinion, in talking to people who generally aren't lawyers or who might not be kind of up to speed on this issue, it was interesting for me to see and to hear from people saying, wow, this must not have been that controversial, or like, this is kind of an obvious an outcome. And I was like, that's wonderful that that's the direction that people are taking this, and that's how people are thinking about this case. Because if you had told me 2 years ago when we were in the district court or in the Third Circuit arguing about this, it was very controversial. And I think, the fact that even Justices Kagan and Sotomayor and Breyer joined this opinion sends a strong message that, it's not okay to, overrun someone's religious liberty and their constitutional protections based on, nothing more than kind of this vague assertion of equality or non-discrimination, when if you actually dig into what happened in Philadelphia, Catholic Social Services serves all children in need. They're one of the biggest providers of foster care for Black children and larger family groups who have trouble finding placements.
And they've been doing this over 100 years, I think your brief said.
Yeah, they've been doing this longer than the city of Philadelphia has been doing this, and that came up in the opinion as well. So protecting these families who partner with Catholic Social Services and protecting their ability to continue serving was a big focus of the court's opinion as well. The other thing that jumped out to me is kind of the rule that comes out of this opinion. And I think the rule from Fulton is whenever the government has the discretion to grant an exception to its rule or whatever the policy might be, or it engages in individualized determination, that action becomes subject to strict scrutiny. And that, it might.
So under the city's policy, they had given themselves the ability to give exemptions, but then they just refused to give an exemption to Catholic Social Services.
Yeah.
And that refusal is what's subject to strict scrutiny, is that?
Yeah, that's exactly right. So there was a policy called 3.21 in the city's contract that said the city administrator may grant an exception from this requirement that all agencies endorse any family that comes to them. The city never used that policy, and the Supreme Court opinion specifically said, even if they never use that discretion, the fact that the government has the discretion to provide an accommodation means they can't deny that. They can't deny that accommodation. They can't refuse to use that discretion to provide a religious accommodation. Because the danger is, if the government has discretion to pick who's in and who's out, it's very hard to know if those decisions are made on the basis of someone's religious beliefs or some other protected characteristic. So the courts have said that analysis is subject to a higher level of scrutiny. And zooming out of the foster care space, it's hard to find a government regulatory system that doesn't at least have some level of discretion or individualized exemptions. And I think the other key to this is, this comes out in Justice Gorsuch's concurrence. He says the discretion and the language in 3.21 that Chief Justice Roberts gloms onto doesn't actually really cover exactly what CSS wants to do. It's a different part of the kind of contracting scheme. And Gorsuch cites that as a fault in the Chief Justice's reasoning. But on the flip side, it kind of expands the universe of things you can look to when you're challenging a government regulation, because it doesn't have to be exactly this particular component that you're challenging. If there's really discretion anywhere in the system, that's enough to trigger heightened scrutiny, which I think is a really big development and a big change in First Amendment law.
It sounds like it could be. The critics of the decision have said, well, what prevents the city of Philadelphia from just taking away the discretion in its policy, and won't Catholic Social Services be out of luck if the city comes back and reacts that way?
Right, like Justice Alito said in his opinion, this majority is written on magic paper. The ink will disappear as soon as it's written because the city can change its contract. I think the reality is, having dealt with this case, and we've done a couple other foster care cases across the country, it's basically impossible to run a foster care system without having the ability to grant accommodations and exceptions, either for placing children on the basis of race. For example, a lot of city governments are moving in that direction where they're making race-based placements, or if you're rejecting a foster parent because of their mental or physical disabilities, or if you're placing children based on a federal statute that requires Native American children to be placed with Native American families. There's so many ways in which, in the foster care system in particular, government discretion plays a big part that I think is going to be impossible.
In order to serve the best interest of the child.
Right,
presumably.
exactly. So it's a good thing to have it. So it's basically really hard to get rid of it. And once you have it, you can't discriminate against religious people who want an accommodation as well.
Okay. So why did Justice Barrett write separately to concur? What was motivating her in this case?
I think it's hard to kind of read between the tea leaves, but Justice Barrett and Justice Kavanaugh, of course, signed on fully to the majority opinion, but they said, we think this Smith decision from 1990 is wrong, but we're not quite sure we agree with the reasoning and the arguments made by Alito, Gorsuch, and Thomas. So, we're going to save for another day whether to revisit Smith. And I guess to take a quick step back on Smith.
Meaning there wasn't a majority for what those three wanted to do in their separate writing in the case?
So I mean, if you're doing kind of nose counting of the 9 justices, 5 did say Smith was wrongly decided. So if you include Barrett and Kavanaugh, they both said, we think Smith was wrong. The question for Barrett and Kavanaugh was, what should replace it? And Justice Alito, writing for the other 3, said, I think the replacement is to go back to the Sherbert standard, which is a strict scrutiny standard that was applied before Smith. Justice Barrett, in her concurrence, said, I think the textual argument based on the language in the free exercise clause supports that, but I'm not 100% sure about the history. I'm not 100% sure this is the right approach. So that was kind of where they left it. They didn't give an alternative argument. I think, they're maybe kicking the can down the road on that particular issue.
Definitely kicking the can down the road, but how far down the road? I mean, you view the decision as having informed what the next series of cases looking to overturn Smith might look like, for example?
I think that's difficult to know. There's always new cases coming down the pipeline. The Coach Kennedy case, there was just a decision in the 9th Circuit a couple days ago on that one, which will probably head to the Supreme Court at some point.
Is Becket involved in that case?
No, I think we might have filed an amicus brief previously, but that's not one of ours. But I think the challenge.
Can you say a little bit more about that? Because I don't know if our audience is aware of the facts of that case.
Absolutely. So Coach Kennedy, that's a case that went to the Supreme Court a couple years ago, and the court didn't take the petition. Basically, this is a high school football coach who either before games or after games wanted to kneel and say a prayer kind of to himself. Sometimes students would join him, sometimes they wouldn't.
On a voluntary basis.
On a voluntary basis, right. And the question was whether the school had to accommodate his religious exercise or whether they could punish him for engaging in that prayer. So when the Supreme Court denied this in an earlier stage, it might have been at a PI, and now we're at summary judgment. I don't know exactly what stage it's at. I think 3 or 4 justices wrote a dissent from denial, or it might have been an opinion concurring in the denial saying, we think it's time to revisit the Smith decision. And, this might not be the case to do it, but they basically signaled to litigators that they're open to reconsidering the rule from Smith. And, that was kind of what prompted, I think, a lot of cases raising challenges to Smith, including Fulton and a couple others.
Okay, terrific. Are there other cases in the pipeline that you're working on that?
Yeah, we have a petition pending at the court now that challenges New York State's abortion mandate, which requires insurers to provide coverage for abortion. And that would be a problem, of course, for Catholic hospitals in New York. So that petition is pending. There's another petition pending that's not one of our cases, but that's called U.S. versus Minton. I think it's Dignity Health versus Minton. And that one similarly is a Catholic hospitals case challenging requirements that the hospitals provide sterilization and other services that would violate their beliefs. So, the court might consider those next term. But I think the difficulty is finding a case where there isn't some sort of government discretion or some sort of escape hatch, because after Fulton and after Tandon, which was a COVID case, the court decided during its emergency docket, and then after Masterpiece, you have a lot of ways to get around Smith. There can be individualized discretion. There can be categorical exemptions, which is what was the case in Tandon, where the court said, if you allow department stores to be open, you can't keep churches closed. And they said that, privileging this category of secular exemptions means you can't exclude the religious. And then, of course,
Thomas, who said that casinos aren't mentioned in the Constitution, but churches are.
It was either Thomas or Gorsuch, I think, who said that. Yeah. And then the third category is lack of neutrality. So that's Masterpiece Cake Shop, where they said the government decision makers didn't consider the religious beliefs of this individual fairly, and this discrimination triggers heightened scrutiny. So that's 3 different ways to get around Smith, and I think those are pretty big ways to get around Smith.
So there were 2 decisions that came out after Fulton from the Supreme Court this term that I think give us, well, they seem to cut in opposite directions. So I'm hoping maybe you can help us figure out what they mean. On the one hand, there was a case called Amos Mast v. Fillmore County, Minnesota. And this case had to do with, I'm not sure if they were state or local regulations about the disposal of gray water, essentially saying you have to have a septic system for the disposal of gray water. But there was a group of Schwarzentruber Amish who for hundreds of years have not used septic systems and don't have running water and so forth. And the court granted, vacated, and remanded the decision in that case in light of Fulton, which even though it was an Arlupa case, so that would suggest that, well, Fulton isn't just about interpreting one contract between the city of Philadelphia and Catholic Social Services. It cuts more broadly than that. But right about the same time, the court denied cert in Arlene's Flowers, Inc. v. Washington State, which is a case that's gotten a lot of national attention about a florist in Washington State who had a gay customer who she had provided, or I say she, the store had provided lots of flowers to this customer over the years, but refused to provide flowers, as I understand it, for the matrimony ceremony that this customer wanted to engage in. So how does the court hand down Fulton and then make a decision like this in Mast, and then a seemingly different decision in Arlene's Flowers?
Yeah, I think that's a good question. And to your first point about, kind of the scope and extent of Fulton, in Mast, I believe it was Justice Gorsuch who wrote kind of a concurrence in the GVR. And he said the lower court applied the strict scrutiny analysis wrong, because under Arlupa, the actions of the local, I think it was local government there, were automatically subject to strict scrutiny. So the court wasn't applying the kind of buckets of discretion or whatever we were talking about before. This federal statute already required that the local government comply and satisfy strict scrutiny. And what Justice Gorsuch said is Fulton lays out and gives more detail on how the strict scrutiny analysis should work in future cases. So he pointed to the fact that I think 20 or 30 other states allow the Amish to use these basins to filter gray water instead of having a traditional septic system. And he pointed to the fact that if you have a cabin and there's no running water, you can just dump your gray water wherever you want to. So I think he's pointing to the fact that there are ways.
Kind of discrimination.
Yeah, there are other ways to do that.
But if you live in a cabin full time, essentially, like the Amish do, then it's a problem.
Yeah, exactly. So I think the way to make sense of that case is following Fulton, there's additional guidance from the Supreme Court on how to apply the strict scrutiny analysis, and that's what the court was doing in the gray water case. So I think that should be a pretty clear win in the lower courts. I think Justice Gorsuch's opinion gives them a clear path to how to resolve that case. In terms of Arlene's Flowers, I think it's you can never read too much into the court denying a cert petition, because they deny 95, 98% of them. We also had another petition pending that was denied after Fulton, and that was the Ricks case. And that one was on behalf of an individual who didn't want to use his social security number to become a state contractor because he had religious beliefs that providing this number to the government was akin to the mark of the beast, and he didn't want to share that. But they had basically other ways to provide him with this contractor's license. And so the court denied cert in both this case and in Arlene's. I think it might signal the court isn't quite ready to reconsider Smith. Despite having 5 justices who think it's wrong, they might want some more time to figure out what should replace it. So I think that's certainly possible.
Or a fact pattern that's more appealing to them for whatever reason.
Yeah, or a better fact pattern. They might just not be interested in more kind of wedding related cases. I mean, it could be anything like that. But I think it signals the court isn't ready like next term to take on Smith again after having 40 amicus briefs on both sides that addressed it. Like they
Which I
got
think was
briefing.
the record for the term, if I'm not.
I think it was the
mistaken,
most
or
for the term.
maybe our next case might
Yeah,
have had
yeah.
the record. Anything else you wanted to say there, or we'll come back to Fulton
Yeah.
in a minute? But
Yeah, that's great.
okay. So the next case I wanted to talk about is Americans for Prosperity Foundation v. Take Your Pick. It started off in the lower courts v. Harris, back when Kamala Harris was the Attorney General of California. For a long time, it was v. Becerra. There was at least one other name in there, but when the court finally handed down the decision, it was v. Bonta, who's the current Attorney General of California. And Jeff, I'll ask these questions to you. I know that you weren't here when we filed the amicus brief in AFPF.
So as an expression of due modesty, I cannot claim any credit for any of your 6 victories this term, Mark.
Well, if we don't have this good a record next term, though, we'll have to come knocking on your door again. Just kidding. So the holding in, the issue in Americans for Prosperity Foundation v. Bonta was whether or not the state of California could require nonprofit organizations, 501c3 organizations like the New Civil Liberties Alliance, like Becket, for example, to turn over their complete tax return. So most of a tax return of a 501c3 organization is already public, but there's something called your Schedule B, which is not public. And the Schedule B lists your largest donors, typically. Is that, and there's a little bit more information, but the information that the California Attorney General claimed to be interested in was, who are these donors and how much are they giving you, and so forth. Well, this Schedule B information is not public information. The IRS is not allowed to disclose that information, but the California Attorney General said, well, I want that information, so turn it over, and you 501c3 organizations cannot solicit funds in the state of California unless you do turn over your Schedule B information to the Attorney General. Well, let me start with maybe a general question. What's wrong with that, Jeff? Why wouldn't people want to turn over their Schedule Bs to the Attorney General of California?
Well, there's an obvious chilling effect that has. And indeed, I think that the trial judge in this case, Judge Real, made really excellent factual findings that I think made it quite difficult conceptually for the dissenters, in my mind anyway, to get off the ground. There were just repeated disclosures. There was a situation where a technology contractor said, oh, now I know who a CEO is, I can go in and put a knife to his throat. So that's just, that's a physical chilling. But I think the ordinary conception of chilling goes back to the NAACP membership list cases that I think most people who have gone through law school are familiar with, that was unlawful. And that leads the dissent sort of in the line of saying, well, that was Jim Crow, but this is a different situation. And 1/4 of the charitable assets of the nation are administered through California, and therefore the AG of California has supervisory authority over that. And so, he has important regulatory interests.
What do you make of the fact that the Supreme Court noted that despite having the supervisory authority, it didn't appear that the Attorney General had actually relied on Schedule B information for any of the various investigations that it's launched
Right.
And the fraud in the philanthropy area.
Right. Those are part of the excellent factual findings, I think, that the trial judge made, that he couldn't find a single instance in which they'd either been used in that way to justify that interest. So it was just a theoretical interest that was being used to defend the regime, as opposed to, actually saying that's how they used it on the ground. And no instances really that the database was queried in that way. So that's pretty remarkable, I think, in showing that was just pretextual. That's not really why the state wanted that. Now, the majority opinion, and then it gets more complicated, as I'm sure you're going to get into there. For one aspect of it, there's a plurality, very small part of the opinion But the majority basically doesn't use the term pretextual, but I think that kind of screams off the page anyway.
Yeah, well, let's jump right into that. So the majority holding, and you referenced this, but the thrust of the amicus brief that NCLA filed in this case did go back to the NAACP, the Alabama X. Rel. Patterson case from 1958, I believe it is. And the Patterson who's named in that case was the Attorney General of Alabama. And in that case, the Alabama Attorney General was trying to get the membership lists of the NAACP, also ostensibly for sort of investigatory reasons. There were, I can't remember now if the argument was that the NAACP may not have dotted all its I's and crossed its T's on its incorporation papers, or there was something like that was ostensibly under the authority of the Attorney General to investigate. But no one thought that's really why the Attorney General wanted the membership lists of the NAACP in 1958 in Alabama, right? So, so the Supreme Court was wise to what was going on, and they protected the anonymity interests of the NAACP in order to protect the First Amendment association rights of the NAACP. Well, fast forward to 2021, it's the same issue, right? It's the associational freedom of organizations like NCLA or Becket or the Americans for Prosperity Foundation, or I believe, what was the companion case? St. Thomas
More Society.
Yeah. And these are, there is a chilling effect for donors to these organizations if they know that their identity and the amount of their contribution is going to be divulged to authorities, in this case, the Attorney General of California, who are opposed ideologically to the contributions that they're making. So how did the majority handle that? And was NAACP v. Alabama fully vindicated by the majority here? Again, I should say, Chief Justice, maybe that's the connection between Fulton. Chief Justice Roberts writing for the majority, but this time in a 6-3, much more divisive set of opinions.
So I thought actually the seg you were going to try to do from Fulton to Bonta was going to be based on standards of scrutiny fest, because I think that's all over this case. So I do want to say something about that.
Sure.
And I have a meta point about that, but let me try to answer your question. I think it does vindicate that. I think it vindicates that those decades old decisions should be applied neutrally, and that they shouldn't essentially be discarded or as I'm fond of this term, nerfed.
You better explain it, because I had no idea what it meant.
So, well, I played a lot of Nerf football and some regular football too, but Nerf football, right, is made out of like a soft foam, so it can't really hurt you. So if you take a hard-edged rule and you soften it and create a lot of exceptions, then it's a nerfed rule. So, I think that the pitch was you're nerfing that you should nerf this, because we're not talking about, protecting people who are being racially discriminated against under Jim Crow. We're talking instead about, a free enterprise group and, a religiously connected organization, and somehow they should be entitled to less scrutiny. And the majority clearly didn't buy that. So in terms of the whole scrutiny, fest, right? I mean, there are really kind of three potential standards on the table, and the court winds up picking the one in the middle. So, the government's arguing that as long as there's kind of a substantial relationship, to what they say their ostensible government purposes are, and seeking this membership information, then that's good enough. At the other end of the spectrum, the petitioners, or it gets a little complicated in terms of what their fallback arguments were, but they were asking, in some form for strict scrutiny, and then the standard that the plurality applies is so-called exacting scrutiny. And so,
now, is that the same exacting scrutiny that was used below? Because the Ninth Circuit's version of exacting scrutiny was not very exacting in this case.
That's right. That's probably why, Alito and Gorsuch wrote separately in their concurrence to say, kind of one major point, the exacting scrutiny test has real teeth. I think that's actually a direct quote. So in the Ninth Circuit's version, it was, I continue with my analogy, Mark, it was nerfed. So for that reason, that they were stressing that. Now,
It might have been Whiffle.
You go, well, yeah, I can create a whole continuum down to Whiffle. In terms of the majority or I should say on this issue, the plurality, the Alito and Gorsuch, concurrence versus the Thomas concurrence, I think it shakes out like this. The Chief and Kavanaugh and Barrett, they think apply exacting scrutiny. This California regime flunks it. Justice Thomas's view is let's just,
But flunks it why?
Flunks it because of, really all of these reasons that show that I think it was pretextual, right? Like it hadn't been enforced. They first enforced it starting in 2010. There's no evidence that they had actually ever even bothered to query the database, for the proper reasons they said they would want to do that for.
A lot of these donors are out-of-state donors too, right? So if you were to list the top 5 or 10 donors of most major 501c3 organizations, they're not necessarily going to be California donors. And the Attorney General of California doesn't have jurisdiction to go sort of protect those out-of-state donors to an out-of-state organization.
Right. And then,
there's no nexus there.
So that's the factual component, but I'd also say as a legal matter, they have a nice quip, which is, cross-cutting, that, the primary purpose of the First Amendment, associational rights is not efficiency. So even if, the California folks have a decent efficiency argument, their view is that's not good enough.
But it sounded like at least the view of those three, and probably the dissenters as well, is that if there were a particular case where the government was investigating, they might be able to get this information with a subpoena or something like that. There's just not an ability to sort of get it wholesale.
I mean, that would be so that's the fight between the exacting scrutiny and the strict scrutiny really would be whether you're using the least restrictive means. And the least restrictive means would probably just, naturally be, we'll go subpoena it in a particular case where you have a reasonable suspicion that there's some fraud going on in the charity. And fraud is a serious problem as to charities, and so not to diminish that, but clearly California had a blunderbuss approach of just trying to blast out the information about this. And I think it's one thing, Mark, actually to show that even if you're going to compare a free market organization and neutrally and a religious organization to Jim Crow laws. In the modern era, right, you have social media and how that leverages everything, right? Once the donor lists are up on the net, then you just have a massive, kind of private augmentation of harassment potential. And I think, the court and certainly their clerks of a, more recent vintage are aware of that kind of multiplying factor.
Well, I think that's why there were dozens and dozens of amicus briefs in this case, is
Yes.
because every group out there that relies on private donations is concerned about that exact social media amplification effect.
Right. And the Chief Justice makes the point about the vast number of amici here on the side that the majority / plurality accepts.
From all ideological angles,
right.
By the way. I think Planned Parenthood filed in this case. I know NAACP did. So
I think the most striking kind of bookend continuum that he gives is CARE, the Islamic organization at one end, and then the Zionists of America at the other end. So, this really ran the gamut of folks who were like, no, you shouldn't be, doing this blitz disclosure. So let me make the meta point about the standards of review, because I mean, one view of standards of review is where do they come from, right? There's nothing like that in the text of the Constitution. And so I think that it's kind of a handmaiden of balancing. As soon as you establish that there are different tiers of standards of review, right, you're inherently suggesting that if the government makes a good enough case and you weigh its equities in a given case, right, then you can come to the conclusion that something that if the government had lesser equities might be ruled unconstitutional. So I think, and this is consistent.
So your rights wax and wane based on the government's equities.
Yes,
That's not usually how one thinks of rights.
exactly. And certainly that's not, our mission here at NCLA, which is to push back on that. But I also think to take the title of your of the presentation here, right, sort of raising questions about, these cases are accomplishments, but
Saving civil liberties or barely bothering.
or the barely bothering part of that, right, the parenthetical is that I think that these kinds of cases set up a kind of dynamic that leads to the government getting more and more sophisticated. So, on these facts, California flunked, but, much like you were discussing, well, what happens if they try to strip out discretion from the foster care regime, right? Although, your view is that, it might be hard to do that, especially given kind of the ordinary backdrop of child protection law and what the assumptions are there. But, certainly in this situation, different ordinary backdrop, might be easier for California to look at all of the pitfalls in this case, come back for a round 2 and try and see if they can penetrate more into donor lists.
Disclosure of California donors or something like that.
Yes.
So you said that there was a piece you wanted to get to on the plurality.
So the pluralities view, right, is okay, well, we're going to apply exacting scrutiny, and exacting scrutiny, some say, is limited to the election context, but we haven't limited it to the election context, and we've applied it to all sorts of types of beliefs. I think Justice Thomas is much more skeptical about this exacting scrutiny concept, and the Gorsuch and Alito basically say, well, we might want to look at this whole concept of whether exacting scrutiny applies to this kind of situation as well, but we don't need to do it here because basically this California regime is a no-brainer. It flunks either strict scrutiny or exacting scrutiny.
So you mentioned the election cases. The thing that jumped out at me is that there was a real sort of effort below in the Ninth Circuit and also just throughout this case to try to apply election law to the donor disclosure, so sort of election donor disclosure law to the 501c3 donor disclosure context. And the court seems to have shot that down as well and said, no, these are two different contexts.
Right.
When we're talking about elections, you want some transparency. When you're talking about the private conduct of 501c3 organizations, then the same transparency isn't, the same arguments for transparency don't necessarily apply.
Right. So maybe that's a good segue to talk about one of Justice Thomas's other points in his concurrence, because the reality, right, is if you apply this exacting scrutiny in one context and you have a sort of presumption of broader disclosure, but you apply it in another context and you have a sort of presumption of, keeping things confidential in order to promote the reason why, charitable organizations, can drum up donations, that, do you really have, a cross-cutting standardized standard of review, or is it really just kind of a case-by-case analysis? And, he doesn't leap off from the point you're raising there, Mark, that we just and I just reacted to. But what he does say is, look, I question this whole idea of facial challenges isn't something that isn't allowing for facial challenges, and the majority winds up saying that this statute is facially invalid. He questions that both in terms of his general questions about overbreadth doctrine, but also because he thinks that facial kinds of problems, invalidating a statute on a facial ground is something that might violate Article 3, right? That it's just a walking group of advisory opinions. Instead, we should just wait for each case to present itself on the facts, resolve, the First Amendment right in that context and in other contexts constitutionally, and go forward.
Right. I wanted to give Nick a chance to jump in here because I know Becket wrote an amicus brief, and I'll pitch you one question about AFPF, but if there's something else you want to answer, go ahead. But one of the things that NCLA talked about in our amicus brief was the fact that in all or almost all of the major sort of religions, there's this concept of anonymous donors, right? Mm-hmm. So certainly in Christianity, Judaism, and Islam, there's this concept that you don't want the right hand to know what the left hand is doing, or there are other ways that there are other verses that speak to that. And if you force disclosure of, for St. Thomas More or whoever, if you force disclosure of who the biggest donors are, then you're forcing non-anonymity on people, and you're turning what was in the opinion of these, in the theological opinion of these religious organizations, you're taking what was then an act of a certain level of sort of praiseworthiness, and you're taking it down a notch because it's no longer an anonymous act. I don't, unless I missed it, I didn't see the court really speaking to that in the decision. But
yeah, it was interesting. So Becket's amicus brief touched on that point as well, but we grounded it in the freedom of assembly. One thing that we've been pushing for a while is the idea that the court's focus on this expressive association right isn't in the text of the Constitution. There's no right to association in that broader sense. It's a right to freedom of assembly. And so we tried to ground it in that. And actually, Justice Barrett, during oral argument, specifically talked about Beckett's brief and asked the litigants to address this assembly point. So we were optimistic there might be something in the court's opinion that maybe pushed the law in that direction. That's something John Inazu has written a lot about. He's a law professor at UVA. But the court didn't end up taking that up. But yeah, we did a deeper dive into some of the history of anonymous assembly as well, and how these religious groups would kind of protect the rights of their members to meet and to assemble and for prayer and other things like that as well, and how important that anonymity is, especially today. We talked some about the social media and that aspect of it as well. One thing that jumped out to me, kind of to a point you were just raising, is similar to in Fulton, could California clean up its act and request these 990 forms in the future? Because so much of the opinion did turn on the fact that California leaked like a sieve, and these were publicly available at one point in time. If you knew the right URL, you could just go through and pull them all off the web. I think
By changing one digit.
right, it was like super easy. You could just like download them all. But I think one thing that was encouraging, kind of going back to our discussion of strict scrutiny and tiers of scrutiny, is the court said basically every other state in the country is able to police charitable donations without this information.
right, there were
So, like,
48
why?
states didn't do this, and 2 states, or maybe it was 3 states,
Yeah,
did do this. I think New York,
small
and
number,
I can't remember, Pennsylvania, maybe.
Right. So like that's an important thing that came up in the Amish Greywater case as well. Like, if other people can provide this religious accommodation, or if other people can police their charitable donations without using a vacuum to suck up everyone's information, why do you need it? And I think that's a stronger argument than the fact that California leaked like a sieve. And I think that's that gives me some hope that the court in the future, when it's applying strict scrutiny in these cases, might still prevent that information from being disclosed.
Yeah, because when the Second Circuit upheld New York's practice, they sort of pointed to California mockingly and said, well, we're not California. No, New York has done a really good job of keeping this information under wraps. So, we can uphold it here, unlike what was going on over there.
Yeah. And then the one other thing I was going to say on tiers of scrutiny, is recently there's been more and more discussion from academics and others as to where to ground that in the Constitution. Should it just be gotten rid of completely? Like you all were saying, is it really a constitutional right if it's balanced against something else? Where is that in the First Amendment? I think after this term, it seems like, at least for now, the justices have no interest in getting rid of the tiers of scrutiny. Obviously, Barrett talks a lot about that in AFP. Justice Alito, in his concurrence in Fulton, tries to ground some of the strict scrutiny analysis in the state constitutional provisions that preceded the First Amendment, saying that these health and safety provisos in those state constitutions that say your rights are protected as long as they don't endanger the health and safety of the public. He's saying, well, they passed the Constitution with that in the background. And so they kind of understood that there was some limit to your rights, but it's kind of a pretty far limit. He's saying health and safety is a pretty high standard to me.
Yeah, well, health and safety is different than the curiosity of the AG. I mean,
exactly.
Those are not the same thing.
Right. So I see the court keeping the tiers of scrutiny for a while. I don't think the justices are looking to get rid of them, and they're reaching to try to find ways to justify them from an originalist perspective too.
Rich, I haven't included you in the conversation here for a while. Did you want to jump in on anything, either with the AFP case or the Fulton case, with some of your
Well,
thoughts?
I want to repeat what Jeff has said about the AFP case, that the Supreme Court really does seem to be much more concerned with privacy rights generally and First Amendment rights in the light of the internet age and the increased access people have to information. I think you saw that in this case, and the court went out of its way to say times are different now. We need to, if anything, strengthen the sorts of First Amendment rights that we recognized in the NAACP case. You see that in other areas. So, for example, there have been several major Fourth Amendment decisions that Chief Justice Roberts has written, in which he has said that with all of the new surveillance techniques that are available to the government, we really have to rethink Fourth Amendment rights and realize that that the protections that were intended in the 18th century really need to have to be applied in light of the new realities.
Yeah, someone should tell the Seventh Circuit that there's a horrible decision out of the Seventh Circuit. Maybe we'll get to that in a luncheon law later this year.
Can I make one point about
Sure. We're gonna
Rich's
open it
case?
up to questions, so be thinking about questions out here in the audience.
So Richard, one observation I have about, why even so it's really striking, and Mark asked this question, right, that particularly when you look at the statute and it says that if they do go through the FTC does go through the administrative process, that the factual findings are conclusive, right? And then the decision goes, up to the Court of Appeals for review. And so from that perspective, right, it would seem like you're potentially worse off maybe in the administrative process compared to the FTC sues you and goes to federal district court, right? And then you get an appeal after that.
Since the FTC never loses in its own courts.
Right. So, which is another issue, obviously, we're looking hard at. So, so then you might ask the question, well, then why is the FTC interested in doing this? And I think that one reason might be because of the differences in the levels of court, right? That, the FTC gets to choose what court they're going to pursue you in, right? At least within some boundary points, right? And then they get a district judge, and they might win some, they might lose some, but they're pretty good strategically at picking their cases. But if they have to essentially go through an ALJ process, then it's open to them being taken to the Court of Appeals. So even though they're the factual arguments are kind of a dead letter at that point, right? That you're going to get a panel of 3 judges to look at your legal arguments for the first time, and the FTC might actually prefer. And I bet I don't know this for sure, so this is a surmise. But if you looked at the settlement statistics, that a lot of folks, like if they get an adverse decision from a district judge, even at some stage, it's a game over, right? And people just roll over and sign a settlement agreement generally. So that was just one observation.
Sure. Well, let me throw it open to the audience if you have questions on any of these cases. Judy, were you signaling that there was a question from someone online, or no?
Yes, we have a question from someone online. Mark, if you would repeat it after I tell you for.
Sure, I will repeat the question after you say it.
Is there any practical way to attack the administrative state at the root rather than by going after numerous incarnations of it?
Is there any practical way to attack the administrative state at the root instead of going after, did you say different incarnations of it?
Numerous incarnations.
Numerous incarnations of it.
Well, I have a lot of faith in the democratic process and the adoption of legislation. For example, when people were concerned following the Smith decision that the administrative state could be used then to go after religious organizations, Congress responded by adopting RFRA. And so that we now at the federal level anyway have a fairly robust protection for religious groups. And I would think that if places like Philadelphia were to try to continue to go after the Catholic Church, I suspect that even though public opinion on gay marriage has changed, that you would find that the great majority of people in Philadelphia, when it came to the electoral process, would say, we're not in favor of trying to strike down the Catholic Church. We think they generally provide very good services, and we think we're just shooting ourselves in the foot if we were to try to pass a law. So I think that the best way to strike down the administrative state is through Congress and through state legislatures.
Well, certainly part of the theory that NCLA operates under is that the problem with the administrative state is that it's taking decisions away from voters, right? It's turning voting rights into something that is meaningless, because if more and more decisions are made by the elites in the administrative agencies rather than by your elected representatives in the representative bodies of the government, then you're being cut out of the process. That's not self-government when agencies are telling you what to do rather than you telling your elected leaders what you want to have done. Jeff, you want to jump in on that?
Yeah. So I what I would say, I'll leave the legislative point. I think you guys, covered that. But in terms of what you do in the courts, right, and to advert to our founder, Professor Hamburger, in his book, Is Administrative Law Unlawful? It was clear, I think, as he lays out, makes the strong historical case for that, the folks who set up the Republic didn't want to have a system in which the king and his agents had all of this prerogatory administrative power. And so that, I think that patrimony, as it were, that was inherited by the founders in the early Republic, that didn't disappear overnight. It was eroded gradually in decision after decision after decision, right? First, you get, well, you can delegate some things and it's not a violation of the non-delegation doctrine. Then that expands over time. And then pretty soon, you're at American Trucking, and, Justice Scalia is writing that it's sort of a, almost non-enforceable, because we upheld in the NBC case that the FCC can regulate for public convenience and necessity. And, that's just gigantic power handoff, right? So I think that the way that the Constitution can be reconstructed and the administrative state genie can be put back in the bottle, it's inherently going to be case by case if you don't make big progress on legislative reform.
The other thing I would say about that is the strategy that NCLA pursues, and I can understand why it may be frustrating to people who are watching from afar and seeing the sort of case by case development and so forth. But the strategy, the way we pick our cases, is to find cases where we can take tools and tactics away from the administrative state that are relevant in more than just the case that we're proceeding in. And if you can do that, and I think that the AMG v. FTC case is a good example of that, even though that was an amicus effort by us, we weren't representing the party there. If you can take a tool, a tactic away from the administrative state, a tool or tactic that they're using to violate people's civil liberties, then you're going to advance the ball. And that's what we're trying to do. And if you advance the ball far enough, then you have an administrative state that's respecting people's civil liberties. And then whether the size of the administrative state may not matter that much. If it's staying within constitutional bounds, it's respecting civil liberties, it's dotting the I's and crossing the T's when it comes to all the different constitutional restrictions that are in place, then the size or the number of agencies, that may not be as relevant a factor as it would be otherwise. But right now we just have a Leviathan that is shredding the Constitution every day. That's a real problem. Any other questions from sir?
Does the FTC ruling sort of open the door to readdress fines and penalties that were assessed in the past?
I'm going to just repeat that question. Does the FTC ruling reopen the door to reassessing some of the fines and penalties that were handed down in the past?
If the penalties had gone through a final judgment, it's pretty tough to try to reopen them. But there are any number of cases that are still on review as a result of this decision. All of those fines are subject to challenge, and there is ongoing litigation right now. I think the FTC recognizes that its ability to impose those fines is highly suspect, but what it is doing is saying, well, we can use our injunctive power to take over the company and to impose a receivership, and then, of course, once we do that, then we can control all of their assets to the extent there are any. So there are lots of fights ongoing.
Will this resound outside the FTC context at all, Rich, or is the decision solely a statutory interpretation for FTC, or maybe another way of asking is the court's willingness to read the text of the statute to cabin the FTC even, 40, 50 years after the fact. Is that going to maybe, is that a shot across the bow for some of these other agencies that, I don't know, just to name one, may have had an illegal rule in place since 1972 at the SEC involving gag orders?
Well, the SEC actually pretty much won a case last year in a case called Liu, because the FTC does have statutory authority to seek equitable relief, and the Supreme Court said that should be relatively broadly construed. But there are other agencies that don't have that power to seek equitable relief, but nonetheless have been using their authority to get injunctions to try to get damages. One that comes to mind that I've dealt with quite a bit is the Food and Drug Administration. And I have been keeping my eyes open to look for cases to challenge where the FDA goes into court and seeks to recover huge amounts of damages where they don't really have statutory authority to do that.
So bearing on Rich's case, it was interesting that this related to something that when I was in the government, I wrote a memo about in the environmental area. And so my answer to that question was that there's very careful statutory analysis and structural analysis of all of the relevant provisions of the FTC Act that I think that case hinges on. But they do talk about, some general case. That they do talk about the fact that, because there was an argument made essentially that under this Porter case, right, we have the, all the traditional equitable powers come in, right? And then they contrast that with this case, KFC Megrig, which is an environmental case involving RCRA. And so, the basic, the form of analysis that they used, and the majority says we're going to apply. I'm sorry, that the unanimous court says we're going to apply. We find the sort of approach of Megrig, instructional. That was found that you could not have certain remedies under RCRA because just fitting under a general equitable rubric, because the statute really dealt with it in a more specific and limited way elsewhere. So the memo that I had written actually was about, what do you do? Some environmental statutes say that you can seek mitigation as a form of injunctive relief, and other statutes are silent on that. And so, the analysis was, look, you have to always look at the individual statute, but, as a general matter, you're really talking about sort of something that fits under the, equitable hood, right? It's not like it crosses the blood-brain barrier into something that's disguised damages or monetary civil penalties, right? So, but interestingly enough, maybe it's just because I wrote it, within days of the Biden administration taking over, they scrapped that memo. So weirdly, I don't think they did.
Like careful statutory parsing. They'd rather have administrative state just run amok.
I think so.
So hard to believe.
Yeah.
Well, just to follow up what Jeff said, lots of federal agencies have been citing the Porter case, which was back from the 1940s, and said, you see, that particular decision allows a court to enter any kind of relief it thinks is fair to the parties, even if the underlying statute doesn't specifically allow it. And I think one of the best parts about the AMG decision is that it rejected that totally. It said Porter was based on the particular, I think it was a price control statute from the 1940s, and it did not intend to apply a broad rule. So from now on, every agency is going to have to defend itself based on the specific language of their own statutes and not on some general power of the courts to do justice.
Wonderful things happen when the courts redound to the text of statutes that Congress passed rather than just their own precedents. It's really nice to see. Maybe one more question.
From our Zoom audience, can you recommend a good book, perhaps by Professor Hamburger, for the non-lawyer to understand the common problem under your 3 examples?
Well, okay. So the question is, can I recommend a book by Professor Hamburger for the non-legal audience that would explain sort of tie these three examples that we've been talking about today together. I don't know that there's one that would particularly speak to these three cases. He's done a lot of writing in religious liberty, for example, and so there's lots of more articles than, well, I mean, he's written some terrific books on religious liberty as well, but whether they're for the lay audience or not, I can't say so much. But in the administrative state area, he's written a book called The Administrative Threat, which is a small book. I guess I didn't bring the right prop today, but it's we sometimes call it the Little Red Book, but it's a summation of or Cliff's Notes version, if you will, of his 2014 book, Is Administrative Law Unlawful? And I highly recommend that book to non-legal audiences. He also gave a lecture at the Cato Institute that I forget, it was on Constitution Day in 2018, but I forget the name of Cato's Constitution Day lecture. But anyway, he's only given one speech at Cato on Constitution Day, so you can go to their website and find that. I think it's on our website as well. That lecture is a very good summation of his some of his views about administrative power as well. And then I would just invite folks to read the amicus briefs that NCLA puts out and the press releases that we put out. Certainly the work that we do on the communication side of the shop is not geared toward a legal audience. It's geared toward helping regular people understand the stakes in these cases and the ramifications of the various decisions that are coming from the court. So we invite you to be a subscriber, pay attention to our newsletters and other communications. The videos that we put out are also a terrific way to understand some of these issues and some of the cases that we're involved in. And with that, I think we'll wrap up. Thank you for joining us with this edition of Lunch and Law. Rich, Nick, Jeff, thank you for being with us. I really appreciate your insights today. And we'll look forward to having you with us next month for our August Lunch and Law, where Rich Samp will be the moderator to talk about the other three cases that NCLA won at the U.S. Supreme Court this year. So please stay tuned for that. Look forward to having you again.
Thanks.